Good day, everyone. We are here to discuss Book 4 entitled Labor Organization, which is comprised of 3 chapters. Chapter 1, Registration and Cancellation. Chapter 2, Rights and Condition of Membership. And Chapter 3, Rights of Legitimate Labor Organization. We also covered Title 5, the coverage.
So let us start our discussion by defining what is labor organization. Means any union or association of employees which exists in whole or in part for the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment.
So basically, labor organization, this is when a group of employees at a company decides to establish an association or union to protect and promote their interests by bargaining collectively with their employers to get better working conditions, wages, and other benefits. So if this labor organization register in Department of Labor and Employment or DOLE, it will become now as legitimate labor organization.
To be clear, just because a labor organization is not registered with the DOLE doesn't mean it is illegal or legitimate, since freedom of association is guaranteed by the Constitution. However, an unregistered organization does not have the same rights as a member of labor organization, as stated in Article 251. Unregistered labor organizations are still covered under the law that mentions in Articles 258 and 259 that prohibits employers from engaging in unfair labor practices. Registration is not a requirement for workers' organization protection. An unregistered organization is lack of legal personality and thus cannot file a formal complaint in its name. Individual members must be the complainants.
Moreover, association or union should comply a requirements for registration. This is under by Article 234 in order for them to acquire legal personality and to enjoy the rights given to legitimate labor organization. So mag-i-issue ang DOLE ng certification of registration bilang proof na isa silang legitimate labor organization. So ito yung mga requirements na dapat nilang i-comply. These are the requirements for labor organization for issuance of the certificate registration. So take note, these requirements are also applicable in national union or federation and independent union. So first is 50 pesos for registration fee. Next, the name of its officers, their addresses, the principal address of the labor organization, the minutes of the organizational meetings, and the list of the workers who participated in such meetings. In case the applicant is an independent union, the name of all its members comprising at least 20% of all the employees in the bargaining unit where it seeks to operate. If the applicant union has been in existence for 1 or more years, copies of its annual financial reports. Lastly, 4 copies of the constitution and bylaws of the applicant union, minutes of its adoption or ratification, and the list of the members who participated in it. So according to Article 237 for the additional requirements for federations or national unions, so if the applicant for registration is a federation or a national union, it shall in addition to the requirements of the preceding articles submit the following. So number 1 is proof of the affiliation of at least 10 locals or chapters, each of which must be a duly recognized collective bargaining agent in the establishment or industry in which it operates, supporting the registration of such applicant, federation, or national union. So last is the names and addresses of the companies where the locals or chapters operate, and the list of all members in each company involved. So let's talk about how labor organization benefits each employee in a workplace. Just as we usually say, two heads are better than one, which means that one employee is generally weaker than employees. So every employee, including temporary workers, is entitled for union membership. According to Article 257, the right of workers to self-organize is guaranteed by the Constitution and the Labor Code. Madalas na nangyayari kasi, the employer overpowers the employee into such accepting the terms and conditions of employment, even though such terms and conditions are below standards provided by the law. This is one of the relevance of being with labor organization in the purpose of dealing in employers. So the powers will be equally divided between the employer and employees. So hindi na basta-basta makaka-impose si employer ng terms and conditions na below standards. Let us proceed in the registration of labor organization. Labor organization are required to submit a application together with the other requirements to the Bureau of Labor Relations and or the Labor Relations Division in the regional offices, the Bureau. Right after that, the VLR or Labor Relations Divisions are given 30 days to filing and process the application for registration. And if the VLR or Labor Relations Divisions has determined that all requirements are completed by the labor organization, the labor organization will be issued a certificate of registration. This will be the time that labor organization will have legal personality and acquire all rights and privileges granted by the law to a legitimate labor organization. Moreover, because of the pandemic, BLR allows submissions of application for registration online, be able to track its status, and immediately be informed when to get the certificate of registration. But the release of the certificate of the registration is by appointment or through courier or postal.
For further information, visit the DOLE website or Department of Labor and Employment at www.blr.dole.gov.ph.
So here are the steps to be followed in online applications. First, apply online through www.blr-hours.dole.com.ph. Second, fill up the application form and scan documentary requirements and submit online. Generate and print application form for notarization. Third, attestation requirements. The application for registration, including all the accompanying documents, shall be certified under oath by its secretary or treasurer, as the case may be unattested to by its president. Fourth, payment of registration fee. An application for registration with complete documents shall be issued a certificate of registration upon payment of prescribed registration fee. Fifth, receive approved certificate. Record the registration in the logbook and inform the applicant that certificate is available for release. Then the applicant will choose a postal or courier service. As what I mentioned, that labor organization is in the purpose of the collective bargaining and dealing with the employer with respect in terms of conditions of employment. And if this labor organization registered in DOLE and not affiliated or associated with other labor organization, it will classified as independent union. And if this independent union decides to affiliate or associate itself into larger labor organizations, we will refer to them as a national union or federation, a group of legitimate labor organizations in a private enterprise organized for collective bargaining or dealing with employers about terms and conditions of employment. When we say affiliate, we're referring to independent union that affiliated itself with a national union or federation. And based on our research, that national union or federation not just required to have affiliate legitimate labor organizations but refers local chapters that will called as chartered local. Sa madaling salita, the national union or federation has the power to create a chartered local by issuing charter certificate. So let us first differentiate the chartered local and affiliate legitimate labor organization. Unchartered local is created by national union in issuance of charter certificate, while affiliate legitimate labor organization is created by independent registration and issuance of certificate of registration by DOLE. Another distinction is ang chartered local need to file certificate of election from the date it was issued a charter certificate to acquire a legal personality, while labor organization acquire all the rights granted by the law upon the issuance of certificate of registration by the DOLE. However, upon the submissions of charter certificate and the names of chapter officers, their addresses, and the principal of chapter and chapter's constitution and bylaws, the chartered local will acquire all the rights granted by the law to a legitimate labor organization.
Workers' association means any group of workers organized for mutual aid and protection of its members, or for any legitimate purpose other than collective bargaining. Then, upon the issuance of the certificate of registration by the Department of Labor and Employment, or DOLE, it will now recognize as legitimate workers' association.
So regarding with the one of the requirements of independent union, that independent union must submit the names of all its members comprising at least 20% of all the employees in the bargaining unit where it seeks to operate. So in a certain establishment, for example in the mall, so it has different personals like cashier, store manager, cleaning and maintenance, security guard, and so on.
there's a possibility that each of that job positions are not the same in the terms of conditions of employment. It means the terms of conditions of employment of cashier would not be applicable in store manager, cleaning and maintenance, security guard, and so on. And in order to address that, the creation of separate collective bargaining agreement for each cluster of job or positions is necessary. So the group of employees that requires separate bargaining agreement is what we call bargaining unit.
Cancellation of registration. Cancellation of registration means that the union is no longer a legitimate labor organization. Its juridical personality, as well as its statutory rights and privilege, are suspended, but the cancellation does not invalidate an otherwise valid CBA which the union entered into before its certificate was cancelled. The principle provided under Section 8, Rule 4 of the Department Order Number 40-03, which provides that the legal personality of a union, after it has been issued a certificate of registration, may be questioned only through an independent petition for cancellation of union registration. Who may seek cancellation or where? Petitions to cancel the registration of a local chapter, affiliate, or workers' association operating within only one region should be filed with the DOLE regional office. Petitions against federations, national or industry unions, trade union centers, or workers' associations operating in more than one region should be filed with the Bureau of Labor Relations. The legal personality or the registration of a legitimate labor organization cannot be questioned collaterally. There must be an independent petition for the canceling the union registration. Cancellation ordered by a regional office is appealable to the Bureau of Labor Relations, and from there, if proper, to the Court of Appeals. Cancellation ordered by the Bureau itself is appealable to the Office of the Dole Secretary, not directly to the GA. Article 245 or 238. Cancellation of Registration Appeal. The certificate of registration of any legitimate labor organization, whether national or local, may be cancelled by the Bureau after due hearing only on the grounds specified in Article 239 hereof. In this article, cancellation of any labor union or organization, whether national or local, can be cancelled by the Bureau. It can be cancelled if the reasons meet the specified grounds in Article 239, as amended by Republic Act Number 9481. Article 246, or also known as 238A. Effect of a petition for cancellation of registration. A petition for cancellation of union registration shall not suspend the proceedings on certification election, nor shall it prevent the filing of a petition for certification election. In case of cancellation, nothing herein shall restrict the right of the union to seek just and equitable remedies in the appropriate courts. When you register for a union organization, it is forbidden to cancel or else be charged for fraud. Because union organization is a serious matter, it is mandate application of labor organization in order for them. It acquired legal personality and to enjoy the rights given by the legitimate labor organization. That is why when you register and cancel, you have the chance to grounds according to law. Grounds for cancellation of union registration by Article 247. The following may constitute grounds for cancellation of union registration. A. Misrepresentation, false statement or fraud in connection with the adoption or ratification of the Constitution and bylaws or amendments thereto, the minutes of ratification, and the list of members who took part in the ratification. B. Misrepresentation, false statements or fraud in connection with the election of officers, minutes of the election of officers, and the list of voters. And lastly, C. Voluntary dissolution by the members. Ratification of Constitution describes the formal ending of a process of setting a constitution into force by a constituent power. If one of the grounds is proven to be true, then the organization will cancel for sure. There are some other list of grounds will be listed down. A. Acting as a labor contractor, or engaging in the cabo system, or otherwise engaging in any activity prohibited by law. B. Entering into collective bargaining agreement, which provide terms and conditions of employment below minimum standards established by law. C. Asking for or accepting attorney's fees or negotiation fees from employers. D. Other than for mandatory activities under this code, checking off special assessments or any other fees without duly signed individual written authorizations of the members. E. Failure to submit list of individual members to the Bureau once a year or whenever required by the Bureau. And last but not the least, failure to comply with requirements under Articles 237 and 238. Article 248 or 239A, Voluntary Cancellation of Registration. The registration of a legitimate labor organization may be cancelled by the organization itself, provided that at least two-thirds of its general membership votes in a meeting duly called for that purpose to dissolve the organization, provided further that an application to cancel registration is thereafter submitted by the board of the organization, attested to by the president thereof. Canceling a union organization can be done by its own members. Place a meeting and vote for cancellation, but the votes may acquired by the general membership of the organization. It has need 2 or 3 votes to able for them to cancel their registration. When you are asked, just go back to Article 247 and say that you did not acknowledge that only one member of the organization and cancel it, because that will be misinterpreted. They should all be able to decide whether to cancel. Article 249 or 240, Equity of the Incumbent. All existing federations and national unions which meet the qualifications of a legitimate labor organization and none of the grounds for cancellation shall continue to maintain their existing affiliates regardless of the nature of the industry and the location of the affiliates. This article explained that the cancellation of registration of the organization may be invalid if there is no ground has been acknowledged. Therefore, the organization may continue and maintain their existing affiliates. Chapter 2 of Labor Organizations, Rights and Conditions of Membership. Rights of Membership. A labor union, supposed to be an instrument of industrial democracy, it has to be an exemplar of honest and democratic and responsible leadership. It basically states that forming a labor union is the best method to achieve a more productive and efficient industry. In terms of leadership and accountability, labor unions should serve as an example to everyone. The officers' authority, even their tenure in office as well as the policy and major decisions of the organization, all are passed upon by the membership. In a labor union, the members, not the officers or directors, are the governing body. The members and officers of a labor union are not the one who oversee and accept the responsibility for the organization's governance. The rights and conditions of membership laid down in Article 250 may be summarized as follows. Political right. The members' right to vote and be voted for, subject to lawful provisions on qualifications and disqualification. Members have the right to vote for anybody they wish to be elected, as well as they have their own freedom whom they wish to be in a position. Deliberate and decision-making right. The members' right to participate in deliberation on major policy and decide them by secret ballot. The part were to cast a ballot and be decided in favor of, subject to legitimate arrangements on capabilities and preclusion. Right over matters. The members' right against excessive fees. The right against unauthorized collection of contributions or unauthorized disbursement. The right to require adequate records of income and expenses, and the right of access to financial records, the right to vote on officers' compensation, the right to vote on proposed special assessment and be deducted a special assessment only with the member. Written authorization. The right of the member in terms of expensive refunds. This right is against the unauthorized bills and payments without the authority of the officers. This explains the right of the member to access the financial records. Right to information. The member's right to inform about the organization's constitution and by the laws, and the collective bargaining agreement about labor laws. Members have the right to know everything happens in the organization, especially the law of the organization, the constitution, and the collective agreement of the union. In addition, members have the right not just to be informed but to know everything within the organization because they were part of it. Can you refuse to join a union? All employees and independent contractors are free to choose to join or not join in a union. It's illegal for a person to pressure another person about their choice. On average, union members get higher pay than non-members. They are also likely to get better sickness and pension benefits, more paid holiday, and more control over things like shifts and working hours. This is because workers join together to negotiate pay and conditions rather than leaving them up to employer. All independent employees and contractors are free and have the power to choose in what union they want to be in. Also, have the power where they don't want to be participated and not being forced on joining in any union. Moreover, members of the union have a chance to get a higher payment than non-members. Complaints who may file. Any union members may file with the regional director a complaint for any violation of the Constitution and bylaws or the rights and conditions of membership under Article 250. However, if the issue involves the entire membership of the union, the complaint should be supported by at least 30% of the members of the union. The complaint may be filed in the regional office where the union is domiciled. Implementing Rules, Book 5, Rule 14, Section 1. The members have the power to file any violation they want to complain. This talks about that members have the rights and conditions as a member, and it supports by the membership under Article 250. It also states that the complaint should or may have at least 30% support from the members of the union. It will never be accepted by the office if the union didn't support the complaint of their member. In addition, the union complaint should be filed in regional office where the union's permanent address. Union account examiners are officers of the Bureau or in the regional offices assigned to conduct an audit of the book accounts of a legitimate labor organization or workers' association. They are a person who is responsible to supervise the book accounts of a legitimate labor organization or the workers' association. They are the personnel who take in charge on managing accounts, and all of them are officers of the Bureau of Regional Office. Union officer. In the election of union officers, only the union members can vote. Non-union members cannot, even they are part of the bargaining unit. A union member can only have the power to vote in union's election. Those non-union members are not be able to vote even they were part of the bargaining unit. As long as they are not a union member, they were not allowed to join and participate to the union's election. The implementing rules before the 1997 amendments used to provide that the union officers in a company should be an employee of that company. Those unions officers in a company are allowed or should be an employee of the said company, so that non-employees are not allowed to be a union officer. It was stated in implementing rules supported before the 1997 amendments. A person who has been convicted by final sentence of a crime involving moral turpitude cannot be elected as a union officer or appointed to any position in union. There is another rule stating that a person has been convicted or been sentenced in any crime, especially when it pertains moral turpitude, he or she is not allowed to be elected at any position in the union. Also, they were not allowed to be appointed as one of the union's vacant position. Crime involving moral turpitude is one by characterized by an act of baseness, vileness, or depravity in three private or social duties, which a man owes his fellow men, or to society in general, contrary to accepted and customary rule of the right and duty between man and man or conduct Contrary justice, honesty, modesty, or good morals means that it's a crime of offense that involves insulting immorality of a person, such as crime involving fraud, dishonesty, or anything against the norms of society. Crimes moral turpitude can have long-lasting impacts to a person's life, especially when the person holds a professional license. This crime also describes shameful wickedness. It is a very extreme departure from ordinary standards of honesty, good morals, justice, or ethics to be shocking to the moral sense of the community. Term of the office refers to the fixed period of 5 years during which the duly elected officers of a labor organization shall discharge the functions of their office. This means that the elected officers of the union should be more productive and do some adjustments and innovation for the union. They can do it for the first 5 years of their term. In impeachment of a union officers, due process must be followed. In every officer that is impeached, the rules and guidelines of the union should be implemented and go after it. The court explicitly ruled that a member of a labor union may be expelled only for a valid cause and by the following the procedure outlined in the Constitution and bylaws of union. Members of the union can only get rid of on his position if he have a acceptable reason to be expelled. In other half, he or she will impeach in a proper way and it will always follow the decision of the regional office. Union officer responsibilities. The responsibilities of union officer are in provision of paragraph L, M, and P of Article 250 must be complied by the union officers. Paragraph M. The books of accounts and other records of the financial activities of any labor organization shall be open to inspections by any officer or member thereof during office hours. One of the responsibility and duty for being a union officer is to be able to allow their accounts and records of the financial activities open for any investigations and inspections, but it can only be done when office hours. Paragraph P. It shall be the duty of any labor organization and its officers to inform its members on the provisions of its constitutions and bylaws, collective bargaining agreement, the prevailing labor relations system, and their rights and obligations under existing labor laws. Another duty of the union's officer is to inform their members by providing such as constitution's law, collective bargaining agreement, their prevailing labor relations system, and all of their rights and obligations under the labor law. Financial safeguard. Under the provision of paragraph L of Article 250 says that treasurer of any labor organization or every officers are responsible for the account of the organization or for the collection management, disbursement, custody or control funds, money and other properties of the organization. According to Article 250, Paragraph L, state that the treasurer of any labor organization or all of the officer is responsible for the account in terms of controlling funds, money, and other properties owned by the organization. Moreover, it is not just one of the officers that is in charge in taking the duty when it comes in financial aspects. Therefore, all of them, the officers, have the authority and responsibility to manage and take good care of it. The rendering of such account shall be made at least once a year. Resolution of the majority of the members of the organization. The accounts shall be duly audited and verified by affidavit, and a copy thereof shall be furnished the Secretary of Labor and Employment. For the fees, the law does not easily allow the collection of special assessment from union members. Both provisions in paragraph N and paragraph O of the Article 250 must be complied with. The law does not allow special assessment from the union members. There is no special assessment fees to get with in the union members unless there is an authorized present letter that is allowing to by the whole union at a general membership meeting, and this assessment fee have its own purpose. Paragraph N. No special assessment or other extraordinary fees may be levied upon the members of a labor organization unless authorized by a written resolution of a majority of all the members at a general membership meeting duly called the purpose. The secretary of the organization shall record the minutes of the meeting including the list of all members present, the votes cast, the purpose of special assessment or fees, and the recipient of such assessment or fees. The record shall be tested too by the President. The secretary of the organization is the one who's in charge in recording the minutes of meeting, the list of the union members who participated on the General Assembly, the votes, and also the purpose of the special assessment and presenting receipt of fees. It also shall be tested and evaluated by the organization's president. Paragraph O. Other than the mandatory activities under the Code, no special assessment, attorney's fees, negotiation fees, or any other extraordinary fees may be checked off from any amount due to an employee without an individual written authorization, duly signed by the employee. The authorization should be specifically state the amount, purpose, and beneficiary of the deduction. Members of the organization should not pay for special assessment fee for attorney, fee for the negotiation, or any fees from any amount without the authorization signed by the employee, and the authorization should state the purpose, amount of it, and any beneficiary deduction. An employer who collects special assessment without being armed with that required General Assembly resolution and the written authorization from each of the union members may be charged with making illegal deductions from the employee's salary. Lastly, the employer who is in charge on collecting the assessment fees should not force any of the organization's member to pay for special assessment fees, and the employer should not do any illegal matters. Each officer or member of the union can be punished or may be charged from making illegal deductions from the employee's salary. The employees have the right and power to file a case against their employer who forced them to collect or deduct fees for the organization.
Chapter 3. Rights of Legitimate Labor Organization. So let us define first what is legitimate labor organization. It is any union or party that exists inside the private sector for the purpose of collective bargaining and accompanied by dealing with employer concerning terms and conditions and contracts of employment. Article 242. Rights of Legitimate Labor Organization. A legitimate labor organization shall have the right to act as the representative of its members for the purpose of collective bargaining. The labor organization designated or selected by the majority of the employees in an appropriate collective bargaining unit for the purpose of collective bargaining shall be the exclusive representative of all employees in such unit for the purpose of collective bargaining. To be certified as the exclusive representative of all the employees in an appropriate bargaining unit for purpose of collective bargaining means to recognize as the agents of all the employees inside the organization for the purpose of bargaining process. To be furnished by the employer upon written request with its annual audited financial statements including the balance sheet and the profit and loss statement within 30 calendar days from the date of receipt of the request after the union has been duly recognized by the employer or certified as the sole and exclusive bargaining representative of the employees in the bargaining unit, or within 60 calendar days before the expiration of the existing collective bargaining agreement or during the collective bargaining negotiation. To own property, real or personal, for the use and benefit of the labor organization and its member. The organization must have their own property aside from the company in which it has benefits for the organization and the subordinates employee itself. To sue and be sued in its registered name, and to undertake all the other activities designed to benefit the organization and its members, including cooperative, housing, welfare, and other projects not contrary to law. Section 17 Republic Act Number 6715 Legitimate labor organizations' income and assets including grants, endowments, gifts, donation, and contribution they may receive from fraternal and similar organization, both domestic and international, that are actually, directly, and exclusively used for their lawful purposes shall be exempt from taxes, duties, and other assessment. Only a SP may revoke the exemption offered hereunder. Not all the labor organization are have the same as rights that mentioned in the article. The rights outlined in this article are not available to every legitimate labor organization, which is LLO. Only the union representing the majority of bargaining unit members has the authority to represent employees in collective bargaining. Even if it is an LLO, the right does not attach to a minority union. The union's authority. A registered labor union has the legal authority to litigate for its members' individual money claim. The union's right to waive or quit claim all or part of the judgment award in favor of individual workers, on the other hand, should not be taken lightly. It must be specifically provided and the employer must deal. Merger and consolidation. Corporation may decide to combine or consolidate. It could be for a variety of reasons, including a desire to improve their value beyond what they could achieve on their own, a desire to diversify their enterprises or buy assets, or a variety of other reasons. Corporation, on the other hand, must carefully examine the terms of the governing laws before entering into mergers and consolidation. Merger is a reorganization of two or more corporations that ends in their consolidation into a single corporation, which is one of the constituent corporation, with one of the constituent corporation disappearing or dissolving and the other remaining. To put it another way, a merger occurs when one or more corporations are absorbed by another existing corporation, which preserves its identity while assuming the rights, privilege, and franchises of the absorbed companies. Article 242A. Reportorial requirements. The following are documents required to be submitted to the Bureau by the legitimate labor organization. A. Its constitution and bylaws or amendments thereto, the minutes of ratification, and the list of members who took part in the ratification of the Constitution and bylaws within 30 days from adoption or ratification of the Constitution and bylaw or amendments thereto. Its list of officer, minutes of the election of the officer, and list of voters within 30 days from election. Its annual financial report within 30 days after the close of every fiscal year, and its list of members at least once a year or whenever required by the Bureau. Failure to comply the above requirement shall not be ground for cancellation of union registration, but shall subject the hearing officer or members to suspension, expulsion from membership, or any appropriate penalty. As inserted by Section 7, Republic Act Number 9481, ang kabiguang sumunod sa hinihiling sa itaas ay hindi batayan sa pagkansela ng pagpaparehistro ng union, ngunit isa sa ilalim ito sa mga suspensyon, pagpapatalsik mula sa pagiging miyembro.
In this coverage, under the Title 5, we're about to discuss who are allowed to form, join, and assist a labor organization, and sino yung mga tao or employees na hindi pinapayagan na sumali, bumuo, or mag-assist ng kahit anong labor organization. Proceeding to the first part of the coverage, there are two different purposes for forming a labor organization. Una, yung para sa collective bargaining, and yung pangalawa is for mutual aid and protection purposes. There are several types of employees who are allowed to join, assist, or form labor organizations for purposes of collective bargaining. Una, yung mga klase ng empleyado na nagtatrabaho sa commercial, industrial, and agricultural enterprises. even yung mga nasa religious, charitable, medical, or educational institutions. These employees are exactly referred to rank and file employees. Meaning, ito yung mga empleyado na yung job position nila ay hindi related sa level ng managerial employees and supervisory staffs. And even itong mga empleyado na to ay nag-ooperate for profit or non-profit, they are still allowed or may karapatan pa rin sila na mag-assist, sumali, or bumuo ng organization for purposes of collective bargaining. Next one is the supervisory employees. So sila yung may mga kakayahan na mag-recommend ng managerial actions such as laying down policies and hiring or dismissing employees, but still included the independent judgment of the managerial employees. So dahil nga ang kakayahan lang nila is mag-recommend, wala silang magagawa kung ano man yung magiging desisyon ng managerial employee or ng boss nila, since nasa managerial employee pa rin yung decision making. Therefore, supervisory staffs are allowed to join, assist, or form labor organization among themselves. They cannot join, assist, or form a labor organization with the rank and file employees. They can only be merged into a single labor organization if they are in same establishment, which is a federation level or national union. To be clear, rank and file and supervisory employee in enterprise level must be separated if they are not in federation level or not in the same establishment, which considered as national union. The next one who are allowed is the alien employees. As you recall, ito yung mga banyaga na nagtatrabaho dito sa atin sa Pilipinas. They are only allowed if they have a valid permit issued by the Department of Labor and Employment. Then, the said alien employee must be granted with equal rights na kagaya sa Filipino workers para bumuo, mag-assist, or sumali sa labor organization for collective bargaining purposes. Next classes of the employees who are allowed is yung mga empleyado na nagtatrabaho sa government corporations na established under corporation code. Meaning, ito yung mga government corporation na registered with the Security and Exchange Commissions. They have undergone the right process accordingly to the corporation code. So the said employees have the right to join, assist, or form a labor organization for collective bargaining purposes. Last is the co-op employees who are not members of their op, meaning sila ay mga empleyado lamang na mga co-owners. Kaya pinapayagan sila or meron silang karapatan na mag-unionize for collective bargaining purposes. So that's all the employees who are allowed to join, assist, or form a labor organization for the purposes of collective bargaining. Moving to the next part of the coverage, those employees allowed to join, assist, or form labor organization, but for mutual aid and protection lamang, hindi para sa collective bargaining purposes. The first class who are allowed according to Article 253 are the ambulant, interment, and itinerant workers, self-employed people, rural workers, and mga walang definite employers. So dahil nga self-employed sila, wala silang definite employers para makipag-bargain. Kaya yung labor organization nila ay mabisa lamang para sa mutual aid purposes. Next is the civil service employees, other than those which I discussed lately, the government corporations established under corporation code. So yung civil service kasi, they may form organizations for mutual aid purposes only. And they cannot bargain with their employers kasi nasa batas na yung terms and conditions of employment nila sa government. Last are the co-op members, cooperative who are at the same time members of their op, meaning silang talaga yung co-owners ng cooperative. They may form labor organization for mutual aid purposes only and not for collective bargaining purposes, simply because sila na yung employers ng sarili nila and they cannot bargain with themselves. And those are the employees who are allowed to join, assist, or form a labor organization for mutual aid and protection purposes only. Moving to the last part of the coverage, who cannot join, assist, or form a labor organization for any purposes at all. Meaning, meron talagang definite prohibition para sa kanila na ipinagbabawal na bumuo, mag-assist, or sumali sa isang labor organization sa alinmang purposes na nabanggit. First are the managerial employees. Obviously, the manager's loyalty if they be able to join in a union will only form a conflict of interest, simply because the manager's priority is to protect the interests of their company, and maaaring mag-form lamang ng contradictions about isang ipinaglalaban na interest ng collective bargaining unit, either sa rank and file or supervisory employees. Another one who is related to managerial employees are the confidential employees. So itong mga empleyado na to, yung work nila ay related sa field ng managerial functions. Meron silang access sa confidential matters ng mga managerial employees. And kapag sumali sila sa isang union against the employer, they may have exploit the confidentiality of the employers and may use against the managerial employees. Kaya ipinagbabawalan sila na sumali, bumuo, or mag-assist sa kahit anong labor organization. In addition to other classified employees who cannot join, assist, or form labor organization are the high-level employees in government. Same reason in managerial employees. They cannot bargain with themselves. Another are the members of the armed forces of the Philippines, including police officers, firemen, and jail guards, simply because they already have their own organization and cannot join to other organization, meaning dapat maging tapat sila sa tungkulin ginagampanan nila sa bayan, and also that is for security and safety reasons. Plus are the employees of international organization. Kasi yung labor organization dito sa Pilipinas are out of their jurisdiction na. Kaya hindi sila pwedeng sumali sa kahit anumang labor organizations dito sa Pilipinas. And that's all the employees who are not allowed to join, assist, or form a labor organization. In this slide, we're going to discuss the two remaining articles in Title 5 coverage. First, under the Article 256, effects of inclusion as members of employees outside the bargaining unit. This refers dun sa mga employee na nakikisali sa bargaining unit pero hindi talaga sila legitimate member of this bargaining unit. In this case, the said employee will automatically remove to their agenda and it will not cause for the cancellation of the registration of their labor organization. And finally, under Article 257, non-abridgment of the right to self-organization. This may be considered as the general concept for unfair labor practices. Kasi nakasaad dito na labag sa batas ang mag-restrain, coerce, discriminate against the right to self-organization ng kahit sinong empleyado, which is furtherly subject to the provisions of Article 278 of this code. And that's all for the coverage under Title 5.